It takes toilets, disabled toilets on this block, and then if you go down the stairs, if it's right, is the lady into the again. I've been corrected you last. It's an encouragement of solution to availability. And section 58 of the term country plan and it's decision of the council or to contents to repeat submission for the redevelopment and refurbishment of the Tolworth town complex, comprising the changes to the existing floors of Tolworth tower from office use residential, and change the use of the second floor from office use to an ancillary amenity space. Change the use of part of the first floor and part to create flexible work space units. And reduce retail use with necessitated internal alterations and internal refurbishment work. It's also proposed to demolish the existing retail unit, fronting Broadway, and construct two new buildings comprising residential units. On the ground of the first floor, she's on the commercial space, and it's proposed to reconfigure the existing multi-storey car park and service area. We provide traffic parking, walking storage, industrial space, landscape, and public grounds. So, the existing arts centres, travel lodge, and council car park will be retained, but do not walk up posts. The inquiry is scheduled to sit 10 to 12 days. And I've got a number of factors that I need to cover before we move on to hear the evidence. So you could just bear with me. I'm going to start with having the inquiry required. And I've got other formalities to complete. Of course, I go along with it. If there's any questions, if you just raise your hand, I'll try to deal with them. I'm going to start by asking the main classes to introduce themselves, and then check whether anyone else wishes to address the inquiry. So the main causes of the inquiry are the council, the appellant, and I've got two parties. The first one is the Oldham opposition group to Tolworth House, opposition to Tolworth House development group. This is very happy that School Guild group has a bunch and the second one I can discuss in more judgment, but I'm not sure if that's which is areas of 6 part because he didn't attend the expansion conference that's in the case. So it may be that it's just a reducing party. It's that little bit
I've been in the president, he's helping me. He's got COVID, so he may want not be here. Okay?
Thank you. So I've then outlined the procedure for the inquiry. And I looked at the appellant has requested postponement of the inquiry, which I declined on Friday, but they asked to address me on that matter. I have responded in writing. And then following that, I shall identify the main considerations in relation to the appeal and the intermediary order. From what I've read, Council Snow will be pursuing reasons for reviews of 5 and 6, which relate to the proportion of 3-bedroom plus dwellings and the number of affordable dwellings. And subject to mitigation measures secured by the Sector 106 agreement, the Council will not reject proposals on the grounds of parking with highway safety, which was reasonably refusal 8. I understand that reasons for refusal 10 and 11 that relate to sites of parking and surface water drainage are also resolved. But I am aware that some of these matters are pursued by the Rule 6 parties and others, so I will hear evidence in relation to them. What I'm not clear from what I've read is, has the issue regarding the gym been resolved by the Section 106 agreement?
And they instructions on that.
I also want to mention, I did put it in a note to the class, received response, I'm accompanied by two monitors. People that's planning an environmental bar association. They're just here to observe the proceedings and make sure that they're not taking any part in the proceedings. They just familiarise themselves with the inquiry process. On the basis that
I'm going to say, constant, your height, not so it was.
yeah, I checked the past all that stuff.
No objection from
This is something from same chambers, this deliverance doesn't mean that it's got, that there is such a case of having involved together. And anything that I say is still specifically the dimensions. So I'm going to move on to the appearances, that's what we have.
More than one, it's mine.
Uh,
Be upset all. Finance offline, that's COTT, serving LY and ESS. County Council, I'm sort of with the paragraph, over the red, so it's mine,
and I've perspectives, New Kenneth. Sorry, I've got perspectives from Richard Fair, design. David Price on public relevance. Past friendly on energy. And it's story of fire safety. Please,
Madam Chair, sorry to interrupt, but we can't hear when the gentleman's mic is still on. Do you mind speaking more about stuff? Thank you so much, Chair.
So I've got evidence from Richard Baird on design, David Price on public realm and landscape, Carl Stanley on energy, Alex Story on fire safety, Piers Lee on office floor space and viability, and Bob Curry on planning. I do know none of this is a beautiful preference. And I've also got to wrap up the period and this is now made on energy. So for the council,
I'm beginning to spotlight again. So my name is Charles Streeton. Streeton is spelled STREETE for Echo, and for November I'm instructed by the South Dublin Legal Partnership, and I propose to call 3 witnesses: Paul Cahoon on design and public realm, Alex Dwyer on sustainability, and Toby Belton on employment land and planning matters.
I've got proof sentence and last from all 3 witnesses. And although it's not a full proof of evidence, I've also got comments from the health and safety executive. You. And then finally, I've got the old. Sorry,
Just go up further.
Position group. So they represent Mr. Mortimer. Have you got any other witnesses of Mr. Mortimer?
Excuse me. I have no other witnesses. I will be appearing here. Although members of my group may well be in the audience if they can make.
Thank you. And I'll see that you don't come back on the motion, we'll see if we can sort that out. Thank you.
If I may, I was going to get some water, up, but may I get some?
Is that on the stand?
Yes.
Is that everybody? Thank you.
I've just been, I'll remind you that this is still being live streamed, we are currently being live streamed.
Yours.
I'll do So just before I do that, I have proof of evidence from Mr. Mortimer. I have, you need to make you aware that the inquiry is being live streamed, benefit of this, which make it in for any reason. Is there anyone else who wishes to address the inquiry? You could raise your hand. Right. If you could, let's start on the front row, the lady in the colour.
Good morning, my name is Bridget Walker,
Bridget Walker.
resident of, Tolworth for 40 years.
Sorry, Crystal.
No, resident.
Oh, resident. Sorry.
Surbiton for 40 years, just down the road from the site.
Yeah, and you supported on the posting.
Closing.
Gentleman next to you.
Richard Ware.
Sorry, it's. Somebody will. Sorry. Thank you.
Richard Ware, former local residents association, south of the bar. The district residents association. And they say they were local for years. And I'm really here to see what's which is the shadowing or to councils. You residents on here.
I'm not hearing this, sorry, I'm not hearing this, I'm just trying to, store. Can I ask you, the, spare?
I've already got about 10 minutes to speak.
And is Walker, I've got to ask you,
I've got longer than 10 minutes if it's possible.
longer,
Yes.
so can you leave off, is it 20?
I'll say 20, no more than 30, but hopefully
20 to 30 minutes, thank you. And there's
My name is John Allen. I'm going to reduce the context. But the person speaking will be Anthony Evans, who is the vice chair of Kingston Contents.
it's very, very, it's Reverend Rose, probably representing here, thank you. And you're opposed to the term, I think
that's what it is.
and how much do you require?
I'll speak 15 to 20 minutes.
15 to 20 minutes. Yes.
Can I just say that he's not available today, but he is available tomorrow. I don't, of course, the problem with timetabling right now.
Good, thank you for that. Let's see where we get to, and hopefully we can give you an update. Okay. Thank you. Is there anyone else wishes to address the inquiry? No? Thank you. So I've got a copy of the council's letter of notification of the appeal and confirming the date, location of the inquiry and a list to whom that was sent. And a statement where the appeals proceeding on the basis of revised plans that were submitted with the appeal, although they were originally submitted to the council at the time of the application. I held a peace management conference in October where a procedure for consultation was agreed, and there's been a number of representations in relation to that. And I'm satisfied that no party will be prejudiced if I'm to determine the appeal on the basis of the revised plans. I've got copies of the representations made in relation to the original appeal notification and the planning application, and I'll take those into account as well in reaching my decision. Despite being very clear at the case management conference that the matters in dispute should be recorded as such, and a statement of common ground submitted, I've still not had a statement of common ground. I have posted it more than once, and it has been very helpful to my preparation. Is there a reason why we've not had a statement of common?
I think that there's a breakdown in communication because my understanding is that there is an agreed statement of common ground between the parties. So it must be that it hasn't found its way to the proper place rather than that it doesn't exist. It's sort of this later than expected, and we noticed your earlier request for it. It does exist and has existed for a little while, but I'm sorry, I didn't like to say.
Can you forward it to the case, sir, so I can have a copy, please? I think before I go on and out with the procedure, it's probably better that we hear from the appellant as to why they would like a statement rather than having you sit through and in case that the review go down. So it's nice.
And as we will know from Morris Wall that was sent by Sandpaper, the element Thursday, and we request that
When you say first name, it was sort of close to midnight as it was said.
yes, did on Thursday, couldn't see it did on Thursday. We request all the then described the first inquiry, as you was proposed by the council by email. Sent on Friday, the first of December, which following your response to the same date. Can I say at the outset, on behalf of the council, very grateful that that was by you urgently Friday, you know, that was caused some difficulty. We reflect inherently all the content of that response before making the submission that I do to you today. I've already spoken to straight with moments going to say. In short, we request what I think you're not called described the of the inquiry until January, not February, originally requested. And the reasons for that request are as follows. First of all, we understand from very recent discussions with the health and safety executive, the HSC, and so on, first and final list. There is a position that can be described as that one we've seen may not be reflected in the consultation response of the 23rd of October 2023 or the latest response of the 24th of November 2023.
Can I ask you, Mr. Linus, to speed up and keep up with what's about it?
Yes.
Got affected.
I don't think reflected in the consultation response of 23rd of October 23 for the latest response of 24th of November 2023. And the appellants of the appellants managed to speak to the HSC correctly last Thursday afternoon. In particular, Mark Wilson, who is the operational lead for the team that has running Gateway long. The building safety regulator, HSC. He is in fact the author of the earlier response to Sarah Peacock on his time plan. During our conversation, HSC agreed that the subject of resolving any wider procedural matters on the page through June, it would be open to further discussions. In particular, it was indicated that HSC would like to see clear and concise 2 to 4 page documents demonstrating why our proposal is acceptable in terms of our safety, insofar that manifold departure from British South and 999 rather than citing documents which are associated with the final payment. Or the citing documents associated with the final payment. It allows the using verbal process allows Parliament and matter to be addressed. Then we understand that they will engage or have a direct meeting to discuss the represented document as well as the outstanding areas of concern. And the other protective point on that we're also told something that provided public citizen benefit when we queried whether they could update their position before the commencement of the inquiry. That they would endeavour to apply that they did by November, but they would be able to provide a good technical response to all groups. Some of the data costs whether it's included or created or whether it's not being taken. Be that the supplement declared Thursday clearly demonstrated that there could be scope to resolve the outstanding concerns, and it may be without casting any criticism here involved today by the HSC. I really appreciate the cycling through the inquiry process and putting the formal process there, but in any event, the involved with more senior personnel in the HSC, we are now prepared to meet directly with start standards with our not the greater sense of direction, but what they would like to present with. I'm moving mind about where stuff in these global circumstances come up. And that's the first point. Second point, until now, the reality is we can only discuss the case within this way. They have required all contact to be through the council on set removed. Now, this is not any of this council that way agency will to the matter that was met. So the usual manner to resolve issues for planning inquiry hasn't until now been available to us. We understand with HSC that it would only be made available to us, and if you don't there to set out a process for that to happen. Thus far, not being able to speak to them directly or meet them has been an impediment to making progress with them. And we now here have the opportunity to seek to resolve matters if you're prepared to grant the adjournment. We said it was me to making progress on the city. For now, the summer mission. And thirdly, it appears from very recent consultation with Paul from Power Grid, also dated the 24th of November 23, that it's raising concerns largely in concurrence with the HSC, but it appears to have done so without actually seeing any of the plan of the scheme. I did discuss as far as the HSC, it gets sense to try and stuff matters further with LFB. Particularly if they're not really aware of plans that are approved. Now, although we haven't been able to see told regularly that they substantially, there has been an exchange of text, we understand that it's going to be something complete. Provided HSC to attend this, get it request through council. We understand that's what it is, they're treating the council as the approving authority, which is not actually the case as far as the appeal is concerned. But principally, they understand we feel them to make this. The response of 24th of November 23, the first direct response consultation on the latest scheme we've seen just over a week here. And it said, based on incomplete, we said it's a scheme, they haven't actually seen the plan, we understand. And we said we're good ground so that discussion with LFB take place. And that's the third point. The fourth point is this, as a result of all that, we said the fair was effective good dealing these matters, it's the law and discussion take place in the context of this occasion where any other residents is heard. I'm sure result Friday at your college. It's practical for fire safety issues to be resolved as far as practical prior to hearing evidence of the inquiry. And that must be rightly said, but there hasn't been a time available for the ability to have a detailed meeting to discuss matters with HSC or LFD since the date of assault of the December or more particularly since the indicated fall into the scheme on Thursday. We would take a further step and say, oh, they said they want to require time for hearing on as they also want that's about Thursday. The current safety is all clear reports to all parties, wider public. We recognize that if our safety issues cannot be involved, there is clearly issues to be appealed. In those circumstances, what makes sense, we say here are the evidence may prove to be aborted in the event we be maintain objections to the scheme. Furthermore, it appears from the way the conflict presented design evidence that it is addressing power safety is not affected design case. And on this basis, it would appear acceptable to proceed by evidence, including cross-examination, until the council understands whether fire safety related points were to remain part of the design case in opposition to the appeal. And that leaves the fifth point map on journey to January. We've taken on board the difficulty to be expressed in the results about February. We also recognise that now the direct contact can be made with HSE sometime in needed to explore exactly what their position may be. We know that in the response as well, this back to the direct engagement with points made by the D7 and Secretary Statement, which responds to the HSE consultation in October. So we need a little time to meet with the HSE, work through the maybe our efforts on their position, as well as the basis the HSC, concerns. We also need the time to get contact, with LFB, South Division. Given the discussion in the chats, we think was appropriate time scale is to assume that we need to clear evidence in January. We have until this stage originally assumed that because we already set aside the 11th and 12th of January, we would close the dates in January when we could adjourn inquiry 2. That would still leave we said sufficient time in January to hear the evidence, subject to potentially any further dates, January being available to the community soon, present purpose of January. We created a start date for the inquiry. And my submission that all in all visits delay, given the nature of the issues of their settlement. There are a few final points we wish to make. We recognise that the work has gone into making these inquiry arrangements on your part, as well as the council part of the public. What we're dealing with is a recent indication given by the formal council the position may change. It was said that we would place 3D man on the office of this inquiry to facilitate the reckoning that we were able to hold thus far. We're also to address a recent consultation from the record of the council by the LFB, which we need time to address. And these are technical points which you raised in your response. It wouldn't be, we said, fortunate for us to withdraw the entire team with this prospect at this moment to go. The mediation between the parties be debated without anything delay. As far as the response rate the issue call, we would have necessarily do that they should in fact be adjourned. On both reasons, we would submit to you, you should adjourn the inquiry until January to be fixed.
Thank you very much.
I just say to take a short break. And I think it is.
Yes, ma'am. And I'll break that two parts. I'll firstly respond to some of what Mr. Lyon has said, and then I'll give you my reasons why I said it could be adjourned. So in response to Mr. Lyon, I have 3 points. The first is that what he says to you is that the HSE's position may not be reflected in its consultation response, or may not reflect a full understanding of the true position. And I can say that that simply is not borne out by the documents. Firstly, the response from the Health and Safety Executive itself is clearly a considered document. It properly refers to all of the relevant information, and it identifies at paragraph 1.14 to 1.22 a clear issue in terms of the breach of a relevant British standard. So I can say that Health and Safety Executive clearly are fully aware of the position, and they have made that position clear in writing. Secondly, now, there's an email which I've mentioned in the line that I'd like to provide, which was sent to my client yesterday by the Health and Safety Executive. I can have one up to you and ask them to offer copies for everyone. This is an explanation by the Health and Safety Executive of the position which Mr. Lyon has explained to you. And I'm going to start to take a moment to read it and let me know when you have them.
I have some for the benefit. Sorry. I have some for the benefit of people. I see there's several copies there. If you could just summarize quickly what it says. I don't get any else. Can everyone at the back see it with the left? Yes.
I'll summarize. In summary, what this says is that the Health and Safety Executive approached Finance Dawson, and following that conversation, the Health and Safety Executive said it wasn't reversed for discussing its product safety concerns directly. If this is something you want, and that is emphasised in the original, what it then said is that Carl has been in contact again. I think that's the owner of the site. And has instructed his team to produce papers setting out more detailed response to the fire safety concerns. And really people on new man to adjourn the inquiry. What the Health and Safety Executive then say is that they are not going to meet to discuss anything unless you provide a procedure still on the way forward, and that the paper can be prepared, they won't comment on it. So essentially now we say this is the seeking to persuade the Health and Safety Executive to change his view. There's nothing to suggest that there's a misunderstanding in Health and Safety Executive's position. It's simply about saying, well, can we can't persuade you otherwise, and have to read or read the Health and Safety Executive said, well, we'll obviously talk to you, we'll always. But in no way does it undermine the clear and considered position in the document that they put before the inquiry. So that's my first point. Secondly, in terms of the response to Mr. Linus, he relied on that there was only previously contact through the local planning authority. And I accept the fact that his submission and the health and safety executive used the local planning authority as a conduit for its discussions. But on the premise, I think as a result of that, it wasn't possible to resolve this issue sooner. This is a matter that must have been apparent to the appellant since the reason for refusal on grounds of fire safety, that is the reason for refusal. It could and should have been resolved long ago. There is an issue in terms of compliance with the British standard, clearly articulated by the health and safety executive, and that frankly is something which could and should have been resolved before the appeal, let alone before the first day of the inquiry. Thirdly, in response to Mr. Lyons' man, in terms of the adjournment to January, his submission is predicated on it being possible to convene a full inquiry in January. And I don't say that that's necessarily impossible, but I think it would be extremely difficult. We would need to find the time, and we would need, in doing so, consider the availability of all witnesses, counsel, room availability, your availability, and so forth. And just in that regard, while Mr. Lyons was making his argument, making his submissions, my divine witness informed me that he is in Hong Kong and not available until the 24th of January. So we are going to be in very real difficulty in dealing with this inquiry in January. And the reality may well be that it proves possible to deal with the whole inquiry in January, and that there's therefore a much longer delay. We take that into account in my submission when you appraise what's suggested. Bear in mind also that if we adjourn to January, even if there was some change of position, and I don't suggest that's likely at all, but even if there were, the local planning authority would also need an opportunity to consider it, to provide its petition and to move forward. So I essentially say that premise of it being possible in January to reconvene and run an entire inquiry is one which is unlikely to be borne out in reality. The delay would be much longer in truth. I've heard them now debate my own statements that what existing application. And I have three reasons for doing so. Firstly, in that instance, an attempt to take a second bite of the cherry. You've already ruled on the adjournment application. There would need to be some reason why you're persuaded to change your mind, and nothing said today would do that in my submission. Secondly, I say that this application is being made far too late. Applications for adjournment or postponement must be exceptional always. And you'll see that in this procedural guide, paragraph 9.5.11.1, which says, unless there are exceptional reasons, we will refuse requests for postponing the appeal or put it in effect. Appellants should not therefore make their appeal until they are ready to proceed to the decision. Those are the words. And we say that that applies to all appeal first day of the inquiry. That's be something especially acceptable to American adjournment on the first day of an inquiry, and there is nothing so exceptional in this case. On the contrary, what we have here is a last-minute attempt to put clarity, which would cause serious prejudice to good administration and to the other parties who are ready to proceed in relation to this appeal. Finally, we say that providing adjournment would serve no proper purpose. You will have seen the comments of the health and safety executive, and I direct you in particular to paragraphs 1.16 to 1.22 of what they have said in their most recent consultation response. They have identified fundamental fire safety objections. They have made clear by way of their email before December that they're willing to listen, but they have not suggested that there's anything that would cause them to revise those objections. On the contrary, if you look at the substance of the objection, the issue is one relating to compliance with the British standards, which would almost certainly require a design revision to the scheme. Speaking frankly, the appellant has realised there is a fundamental objection to its scheme that is likely to result in the appeal being dismissed, and it is now seeking a stay of execution to try to resolve an issue which cannot be resolved without fundamentally revisiting its proposal. And that simply is not the purpose of the planning appeal process. As we saw from the procedural guide, and also paragraph 16.1 of that guide, which refers to not using the appeal process for evolving schemes, it's not appropriate to submit an appeal until you're ready to proceed to a decision. That is exactly what should have happened here in Italy. There is an attempt now to evolve the scheme, and in short, we say it's not possible to address the issues without making design changes to the proposal. My design witness is due to be called today. He's produced his proof, he's produced his rebuttal, and it is far too late for there to be any further amendments. Such that in those circumstances, an adjustment would serve no proper function. Overall, we say that the appeal could proceed to be determined today, and if the appellant realises, as it appears it does, that a matter stands in the way of the draft plan approval, it should withdraw its appeal and reapply the planning commission having satisfactorily resolved that issue.
This Oxford, do you wish to comment on slides, agenda requests?
Yeah, please. Right. We consider that the fire statement and the
This was, anyone, something not our vote, and I think I just see the fresh. Does that make sense?
sorry, thank you. We feel that the rejection of this appeal and the decision was inevitable based on the fire safety regulations and the design provided. And if I may, I would like to explain why, if you will allow time.
What I'm really, sorry, what I'm really focused on is whether what you feel about so I don't hear your comments about the safety issue in itself, only insofar as the relevance, whether we, actually require the proceed today.
I understand. Right. I would say it was absolutely inevitable because of the structural problems with Tolworth, which are highlighted in Mr. Stanley's group affairs. In addition to which, under the regulations, under the regulations, because we're talking about temples which are well 18 meters high, the regulations of, I believe it is BF 9991 2015, which are quoted in the HSE regulations, clearly state that there should be 2 fire safety corps for resilience purposes. And for the clarification of everyone, a fire safety corps seems to be, and I'm not biased, but I'll explain what said, should be a full staircase with a lift no more than 7.5 meters away, plus a bar. Mr. Stanley clearly states in his proof of evidence that it is structurally difficult. In other words, in words that are simple, impossible to put in an additional an additional lift shaft next to the staircase at the back, which is the second staircase. Apart from which, the appeal building was put in on something like July. The appellants would be quite aware that they need to get perfectly clear by it well before, at the same time as you put in your application for land acquisition, particularly with this type of development. Why did they leave it from July to November to put in the application? Particularly as they are aware that the HSE will only deal through the LPA. Sorry, the Local Planning Authority. Why did they take so long? Why not put in the request by the LPA to sort out the fire safety before we were even asked to put it out? That's 4 months. What were they doing in this time? And yet, the reason they did it is because Mr. Stanley's proof of evidence clearly explains that they cannot put in to safety calls. Right. So, apart from anything else, we don't understand how the HSE can be persuaded, particularly because of the fact that we are talking about a situation after growth when the fire safety have been round proof. Whether that's right or not is not our position. They are going to shut every stable door that they have. And quite right, because if there is a fire, it is not going to be dealt with by people sitting in this room. It is going to be by others who are clambering up 19 stories at 3 o'clock in the morning, dealing with terrified residents who have not a clue what to do. And they will want to make sure that every facility, if this is a new development, that every facility is made available to save lives. and for the applicants not to take account of that sort of factor to us seems incomprehensible. Now, the agency, so that explains the time problem. It also explains why there's going to be difficulty in meeting the HSE's requirements. In terms of the adjournment, the HSE says that to meet our requirements will almost certainly need design changes. Those not going to be resolved by January. This in response to this, it's not affected how you always see the documents. We don't accept that and the demand of explain my students to the stuff. It's really the city. An indication that the account prepared a 34-page documents presenting any rationale or the one, but the HSE is prepared to consider that as well as runs there and obligation and given the option to do that through this inquiry. And the next slides, HSE has already indicated that when we ask them to provide their response and advance the inquiry, they have been in a technical position to do so before the inquiry began. I'm claiming it's just prepared to enter into the meeting. It really wants for this inquiry with the benefits for information presented for the 3 lines which proceeded in. There are clearly a prospect of some progress being achieved, which is not fully reflected in the terms of their consultation response. Second, this agreement accept that the side which the HSE position as you will be aware of, both the opportunities identified in Parliament process is required to set a goal table to discuss matters here by the board members. Not all of the helpful discussions are the issues, the greatest, and the way that's exchange correspondence that are moved to find
Mother stuff. There is to unlock the potential area of difference. It's through a meeting that would take place pursuant in terms of this inquiry. We still maintain that having to deal with matters through the local planning authority without a meeting has been independent to the fact that this got no power safety matters. As far as the bigger concern, I've indicated again in my discussions, it appears that I haven't had a chance to get plans for the scheme. And the town was faced with the first direct consultation response to the LPA arriving the 24th of November, again without them stated plans. In circumstances where the LFB displayed a concurrence to large degree of what HSC has said, and this would really present the first opportunity that we have to sit down with the LFB and understand exactly what their concerns are and whether in fact there is information they're taking the plan on the scheme. But we remediate around to do so. Third point on timing. January launch solution remains feasible as far as the venue is concerned. We don't understand their ability and suitable difficulty council is viable influence. From the town's point of view, we have conducted some investigation. There are venues outside being involved and made available. Through January, the availability of the design witness, we've just found out about that, but again, if you're authorised prepared to entertain the prospect of German speaking for the powers that they matters, there would be a way to be designed to address the time and following the concern. Still in the time of January. As for other points that are made, speaking, we don't accept this application being made to the dates. Other emphasised the prompt for the request for the German was made when we became aware of the HSE position, many being expected response given the indication given on the first opportunity to see that directly out about Thursday. Our very concern was it's something that the HSE used to indicates as helpful. And as far as the parents concerned, being told the preparation of document form along with the meeting would be helpful. That we said change of circumstances when given to the wants and said okay. Inquiry. Even before we'll consider the markets, we faced with the London Fire and Brigade response on the 24th of November as the first direct response consultation carried out by the LPA. Up to the extent of the German inquiry. And as per the previous point, this will inevitably require a evolution of the scheme involving a change design. We don't accept that. There's nothing in what the HSE said most recently in their conversations with the accountant, particularly requests for 2 to 4 page documents confirming why any departure from British 999 was acceptable. That inherently assumes a design change. From the health point of view, we're not seeing this discussing any design change in HSE. Rather, we're explaining to them why the evidence presented in the bar safety evidence, which as I mentioned in my opening submissions, has not actually been addressed in terms yet by the HSE response. And that's why I departure not acceptable. These are matters which do not involve a proposal or art change design of the scheme. It is a case of us going to sit down with the HSE and explain the rationale for the proposals that are presented you. So we don't accept the premise of Lord Friends of Mission to essentially attempt to involve the scheme. No such application to involve the scheme before you as part of this application for insurance. And turning to the six parties submissions, some within the interest in this, we understood an email was sent the first was sent to Mr. Mortimer, raised in July, started with our city, happens to be shipping and all the areas around the school. But beyond that, we started to accept for all the point of Mr. Mortimer raises about the timeline. The planning application was submitted in November 2022. But we understand that HSE were not consulted initially on that application before getting along. And ultimately resolved to see that the date February 27th February. Shortly after which the amount of days so said we should go on to see. As far as we're concerned, we prepared an updated bar snapshot, which ultimately became the bar strategy. Ended up being considered to be an address the agency comments, and it was not then until the consultation response was received from the agency in October, and we realised that further work needed to be done to explain the position. After that, the HSC, as I said, would not accept direct consultation from the account, but only through the LBA, which took place in 10th of October, and then received the consultation response later that month. On the basis then, I think we trying to contact the HSC, which has been last Thursday, and as become clear, we're able to have a meeting with them directly to try and advance knowledge. We simply don't accept, we can say, the consultants of their concerns through our well, for evidence, and we've been trying to estimate the amount of the HSC with the result of the past Thursday and message. So for those reasons, we don't accept that once to pay by either council and fix the you say, it's not, that's pursuing said scheme, as I said previously, it would be proportionate. And in my submission, the fact expect of for our case in circumstance where this thought about the or start the our kid, and if it was take place in terms that may be part and proceed on the basis of
as I understand it, you are hoping that.
We can hear you. You need to speak to the mic.
It's because the items.
Oh, sorry. Thank you. Yes, thank you very much.
Thank you. I don't understand it. You're hoping that your legislation from the health and safety executive that they'll only approach adopted to be acceptable within the scheme, and then we proceed with the evidence. Mr. Lyons, agree that that's next.
Is it possible I can say just a few words? As why I don't think it should be adjourned?
You should think that you get very resolved one resolve as you do. So, so Miss, so I'm going to green light. Can you hear me? You can. Mr. Lyons, if you don't persuade the health and safety, that's what you're proposing is there for. What are you suggesting, like I said, because you said that you didn't see the, result as a result of those discussions.
That's all our, is that there's the agency results, and that's what I was down based on what the agency does are. So there's no application part of the city to come in, be currently for years of those stuff. It's very difficult to say that dogs people aware frankly so the agency would be. There may be some solutions short of event scheme of calls for the information which the agency could be seeking something like that. Certainly, authority, ability, see.
On that basis, what I put forward in my note was that we had the evidence of the exception of fire safety and obviously the planning evidence. In the time that we've got allocated this week and next week. Why is that school?
My sort of the ordinance, then the academy have a decision on progress to be so that it's see the take this. I believe it's difficult to get the that where they read, albeit you're not getting are in the state. In this circumstance, we think it would be good to hear all the way to the need to be confident that in the event that this did not approve through full law would be accepted and not here for good to but not we say the part of the not so this equally it's not appropriate for us to hear evidence, including design evidence, regard where the hearing evidence may prove to be awarded that progress cannot be reached with the agency and the general state I will recognize there's still time objection for the board side. We do not waste environment time this week. And here again, may accept it could be awarded. As I said, the mayor is accused. As we understand, one aspect of the design, this is the design that people are taking out how they consider. We think it'd be good for the council to be right down both design is being the goal getting is not large so it's a part of the design that city design when our
In terms of your suggested timing, and I know that hospital internet, they don't have coverage those 2 days. We're still going to need, I would think, a minimum of 8, maybe 10 days for when we resume. I think from my point of view, it's not just simply an inquiry, it's like a decision afterwards and we have a commitment. So it is very likely that another inspector will be appointed, but I'm engaged from the February completely to June on something else. So we're probably looking at much later than the end to the inquiry. It might be that somebody else can, but I think it's sure that the inspectors in the community quite a few months in the past.
absolutely great application. We want to carry their board events available. We can't start that 12 o'clock. And previously, I thought that there's and that gave the over the venues from the young through that country. We understand there will be venues available. Full full power is available in that venue, the underwriting to very as far as respectability for helmet panels, you said, ultimately, the hearing of the inquiry in January, go ahead and talk your bit to my stuff forward, we still receive this application and not sign.
Okay, I'm except that the venue might not be independent this way from thinking around that. But looking at the dates, I think it's written, is it 24th of January and goodness. It would be better to choose that. So the end of January. So I think to be perfectly reasonable, I'm looking to that's the design, we need to follow that probably. And then as it's pushing, we would need at least 3 days for the 24th of January. They would be advise me. Wednesday.
I also have an inquiry 23rd.
We're inquiring. Okay.
Sorry.
So we
It's also, I think I already said that I wasn't available in February, and in fact, in the last week of January.
Right.
And in fact, looking at my diary, I've actually got a hospital appointment on the 16th of February. So.
So I think really, if we're going to adjourn, we need to be just not able to accommodate it. We're going to adjourn to hear all of you and set that point. Consistently, do you want to comment on anything
Yes, ma'am. A couple of short points. The first of which is a superficial agreement, which I think relies on the fundamental this agreement. Namely, that we would agree on the appropriate for design evidence until the position on fire safety and be resolved. But our position is that the fire safety has been resolved. It's just been resolved unfavourably by the NHS. And so my first submission is that when Mr. Larson, we don't know where negotiations would lead. The response is what actually we do is we have the express position of the HSE, and that position is either they really know that, or they believe the design changes. The HSE has so expressly is what would be required to meet their concerns. I know that Mr. Larson proposed the conversation that his client reports to account than the HSE. Mr. Lyons obviously is speaking on instructions, but what we actually have from the courses now is the email that I provided to the 4th of December. And putting it delicately, I'm not entirely satisfied that Mr. Lyons' instructions are entirely consistent with what is said in that email. Mr. Lyons' instructions appear to be that it's the agency required for requesting additional documents. And what that email did say is that it's actually proposing to put forward. Now, I don't think we need to resolve that he said on that, but I think there's a flag that Mr. Lyons is having to work on the basis of some instructions and a conversation of which he is not present, where we don't have anything in writing. What we do have to see another level. Secondly, then, in terms of reallocation it to another sector, we do say that that's very clearly takes administration that would result. You have also spent time reading into the papers, getting in position ready to deal with this inquiry. And that would all be wasted, that would be thrown away, and ultimately it would be taxpayers who have to carry the cost of that through the funding of the inspector. And that is why an adjustment this later today is fundamentally inappropriate. Thirdly, and finally, in terms of venue, we agree that that's unlikely to be an insuperable objection. But where we are planning this is an attempt to control the inquiry process so as to accommodate the various applications for journal by and we say that that's not acceptable and not appropriate. What would happen is we should proceed to determine the application of the appeal on the basis of what the evidence now. And if that results in the appeal, then so be it. And if the appeal does continue to do the appeal, so be it.
Also, very, very difficult. The year that we have is not any specific way I would say that the department being given. As far as get some borrow, it all back there and the newspaper, so that will be the small part in terms of bid. We don't need to consider being confident on the land to get an indicator we say that is like to say to mortgage and document which set up and why is what we get the I think the second one was made what appears in our here is the HSC as the region you can also be environmental such as this, not entirely already clearly until we understood these boards having direct on purpose the other than indicated with some of the final control of the HSC giving away that's being dealt with the home through home park initially through the local authority. Something being recently said that now the public environment was being affected there on all and dealing with some of these matters and probably the program that looks like we did. I was very contact with inquiry where my suspicion about program started why the complex theory and the question not only get the administration but the allowing HSD participate with the fact that involved with always a concern part of the HSD application. Thank you.
Somebody talked about the versions.
Excuse me. May I have the opportunity of making further comments, please?
Thank you. Thank you all. I'm just using a few of the words that the balance. Can you help for discussion? Sit down and explain. And etc. Now, what I would say, it wasn't in my notes, like I said, but I'll reiterate. The application was the closing date of the application was 24th of February. It was received with refused on the 26th of May. In the documents, the Tolworth Town Complex application documents, it showed that 35 documents were submitted in November 2027. 17 were updated in March, which is after the first. Then 9 more were updated in July. As of the 4th of December, yesterday, there were 158 appeal documents, 31 of which have been amended since the 2nd of November amendments cut-off date because they went directly to residents to say they've got more things to say. So the application has evolved significantly since its initial submission, with major changes such as the addition of a second staircase for fire safety. These alterations submitted post-decision effectively presented in the scheme, not initially reviewed and rejected. This approach undermines the consultation process and burdens the community with repeated assessments. The applicant's history of continual document updates, even during the previous appeals, highlights the pattern of evolving proposals post-submission deadlines, causing procedural unfairness, overwhelming residents and council members with voluminous job orientation. So that is why I do not think it should be adjourned, because we believe it's being used to evolve a scheme. Thank you.
This launch.
So, thank you. We know that, Mr. Lyons, first of all, says that they want to sit down around the table with the HSE. He also said that it was only when the HSE submitted their initial consultation that it said concern in October that there is thought. Given that the standard is for 2 fire rating calls, may I just read out from the proof of evidence submitted by safety.
At this stage to review the
I'm not going to read through what I find the highlights. That the fire safety people for the appellant were fully aware that they could not put in a second firefighting lift shaft structurally within 7.5 meters of the second staircase. And it is covered in paragraphs 5.2 to 5.24 of the BBC document. They knew the problem. They were playing with trying to get that mandatory requirement. The fire safety engineer says in his summary, it is my opinion that they are relying on an opinion of an expert to get round the requirements of the HSE, which are there to save lives. And they have known since July. They have known the difficulties of dealing direct with the HSE. Why did they, and they got a rejected application
on fire safety grounds in May. Why did they not think to contact the HSE via the LPA in July? Why did they only realise that there was a matter of concern in October with the direct response from the HSE? They knew there was a problem. And the last safety evidence says that. They have avoided that issue because it's too complicated or expensive or impossible to solve. They have not said how the HSE is going to react. They have all only said they're going to sit round the table with the HSE and explain. That does not mean that the HSE will agree. All we're doing is just delaying the inevitable. It really needs knocking on the head. Because if nothing else, at least with the new application, we won't hundreds of documents being amended all the time. They get it right with an application, with a fire safety certificate, before it goes any further. Because fire safety certificate with buildings of this height is an essential gateway to actually considering the application. Then, if they're not through that gateway, we're all wasting our time. And taxpayers' money.
Thank you, Mr. Morrison. Mr. Lyons, can you take the meeting with HSE?
We don't just in calls, but then indicated as compared to the council with kids. We're waiting for effective indication from you and German to allow that meeting to take place on stage, but that will be fixed. I just thought well briefly today, but our allegation find goals. So here to be more just general trade, but which were already being below by UMA through the previous CNC. We are not being as Durham to allow the sea, and we're seeking to allow for this several meters of our and secondly, as far as is concerned, as I said before, and HSE were consulted originally, and the application went in, they were consulted in February. We put in our statements, ultimately with the able to explain why we did not think that the concerns threat by the safety executive should be staying for provision to their channels. And we were unable to speak to them directly before the meeting or the consultation took place last week. And as they said, they were, for example, set expectations, received not everything out of the council, not with impediments to something about several matters. So we're not in the position where the HSE position is fixed with their side design change will be required. The latest resolve by full member, paragraph 0, mass agency welcome, full fifth, spirit guidance. It says with full fifth, the current is. We're not entirely sure what that means in the context whereby proof evidence explained by the remand which justify the departure of written part from PS 991 and what we're doing seeking certainly part of it is to again it will be a finding on the point that it is not in the accounts of interest says see what we are doing here is proposing a realistic environmental result where we and the inquiry generally it's not really investing political administration will close the opportunity for a range of important staff consultation in a way that allows inquiry to progress and particularly if there's a call out for being reached that is for our people.
It's coming up to 11:40. I'm going to adjourn until 12:15 and reflect on what I've heard and I'll give you a view on that. Okay, so we're taking a break to 12:15. Okay, thank you.
It's in the center. And we've